everybody, and welcome to the next edition of the Employment Insights podcast. My name is Rebecca Kearney, and I'm a partner in the employment team based in Liverpool. I'm joined today by my colleague Mark Landon, who's a partner based in our London office. So, hello, Mark, and thank you for joining us today.
Yeah, hello. It's a great pleasure.
Thank you. And today we are going to be covering the Employment Rights Act, which I know everybody is probably sick to death of hearing about the Employment Rights Bill. But from the 18th of December 2025, we now have the Employment Rights Act. So I suppose without further ado, Mark, the 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 implementation date, 18th of December 2025, the royal assent, sorry, was considerably later than the government had first envisaged. And how do you believe this has then impacted on the anticipated timetable for, implementation of the Act's various provisions?
Until a week ago, I would have said not much, because actually, despite the fact that because of the ping-ponging between the House of Commons and the House of Lords, the bill didn't receive royal assent till probably 3 or 4 months later than it should have done, and
Yeah.
despite the fact that all the autumn consultations didn't happen. Up until about a week ago, the government were steadfast in saying that the July 2025 roadmap timetable for implementation would be adhered to. And then, of course, what they promptly did was to say, well, actually, no, we're now going to have a revised timetable. And if you look at the revised timetable, a lot of the things in the July timeframe remain, but there are a couple of postponements which are potentially quite significant. So what we've got, the early stuff, which happened both on the 18th of December and some things coming in the 18th of February, are all about industrial relations.
Yeah.
So what happened on the 18th of December was the Employment Rights Act repealed the Minimum Service Levels Act introduced by the Tory government, which,
Yeah.
if you remember, was never actually used. But the idea was that if you were having strike action, you would, in certain key services, have to maintain a sort of 20% staffing level. Well, that's got repealed. And then on the 18th of February this year, what we're going to see are various changes as regards industrial action balance. And in a nutshell, frankly, they're going to make it easier to have a lawful strike. They are simplifying the information that a union must provide. But I guess for most people, a key issue is going to be around the 6th of April 2026. And that's the first point. When we look back at the roadmap in July 25, it just said April, whereas actually we now know it's from the 6th of April.
Yeah.
We're getting, again, with regard to unions, simplification of the rules around trade union recognition. But things that are more relevant to non-unionized employers, there's the doubling of the protective award, where there's a failure to collectively consult, so from 90 to 180 days pay per employee. There are changes to the parental and paternity leave entitlements, and in particular, making those both day one rights, whereas at the moment you need 6 months continuous service to get paternity leave and a year to get parental leave. So those both become day one. Statutory sick pay, as from the 6th of April, will become payable on day one rather than day four. Sexual harassment complaints will become protected disclosures for whistleblowing purposes. Now, in reality, in many cases, they probably would be already, but actually, I think it just makes it much clearer there. Still have to be in the public interest, but I think it adds ammunition, if you like, to a sexual harassment complaint. And then slightly oddly, on the 7th of April, so we wait a whole day for the establishment of the Fair Work Agency. That, of course, is this sort of super enforcement body that's going to combine some of the existing enforcement actions of things like HMRC and the Gang Masters Authority. Although actually the powers of the Fair Work Agency will not come in on the 7th of April. They're going to be some time, because I think the reality is that transferring enforcement action from an existing body to the Fair Work Agency is going to be quite a complicated issue. Then what we have no earlier than August 2026 is the introduction of electronic balloting for statutory trade union ballots. And then we move on to October. Now, two key changes with the new timetable is that the extension of time limits for submitting tribunal claims, currently 3 months from the cause of action to 6 months, well, that has been postponed from October. Well, what they've said is, instead of coming in October, it'll take effect no earlier than October. Well, what that could mean, of course, is this extension could happen, frankly, tomorrow. Because what they're saying is that October is the latest it will happen, but they could bring it in at any time. And in some ways, actually, I don't think that's going to be a hugely significant change, because it's not granting new legal rights. It's just saying that the jurisdiction of the tribunal will be extended to 6 months rather than 3 after the act you're complaining about. But what has been postponed from October is the introduction of various restrictions on an employer's ability to dismiss and re-engage staff, the so-called fire and rehire. That was going to come in October 2026. It's now going to come in on the 1st of January 2027. And there is, in fact, an ongoing consultation exercise on this. And it's an odd one, because if you remember back to the Labour Party manifesto for the general election in July 24, they talked about the scourge of fire and rehire, this sort of Darth Vader-esque legislation. And what they said they were going to do is do an outright ban on the ability to fire and rehire if you want to force through changes in an employment contract. Well, of course, what happened was the Employment Rights Act was watered down. So what they said was, well, there'll be certain restricted variations where this ban would apply, say, for extreme financial difficulties. And actually, if you look at the consultation, it looks like they're watering this down even more, because they're talking about taking certain changes outside the scope of a restricted variation. So, for example, a change in shift wouldn't count as a restricted variation unless it was a sort of severe change. And the example in the consultation is that if you said someone on nights was going to be transferred to days, that would be a restricted variation. But if you were changing somebody from a 9 to 5 till a 10 till 6 shift during the day, that wouldn't be a restricted variation. So presumably you could ultimately use fire and rehire to force it through. So we've got this slightly odd thing where they have pushed it back from October 26 to January 27. But also it looks like they are taking on board the various concerns raised by local government, the CBI, etc., who actually rely upon the ability to fire and rehire to deal with the sort of diehard stick-in-the-muds who won't agree a change. Because, of course, what they don't want is a two-tier workforce where some people agree a change and some don't. So that is one of the significant changes. Other things coming in October: a duty to take all reasonable steps to prevent sexual harassment. Now, at the moment, again, this is one of those things that I think will make no difference at all. At the moment, you have to take reasonable steps to prevent sexual harassment. That really, by adding the word all reasonable steps, it seems to me is to bring it into line with the statutory defence against vicarious liability. But what we have got in October, which I think is going to be quite significant, is the introduction of protection against third-party harassment as regards all 9 protected characteristics. Since October 2024, employers have been under an obligation to protect staff against third-party sexual harassment. But as of October 26, it'll be third-party harassment in respect of all 9 protected characteristics, so disability, religion, gender reassignment, whatever it happens to be. But what is troubling is that the government have said, oh, we're going to publish regulations to explain what these reasonable steps will be to protect staff. But we're not doing that until 2027. So what we've got is a new rule coming out, but actually the regulations that will flesh it out might not be out for anything up to a year after. And I think most employment practitioners will know it's pretty hard to run the existing statutory defence to vicarious liability. And given that employers have significantly less control over what third parties do, as opposed to what your own staff do to each other, I think this is a real issue. If you work in hospitality or retail, I would be very nervous about the October 2026 third-party harassment provisions, because essentially, if they occur in the course of employment and it's found that you didn't take reasonable preventative measures as an employer, you're liable. And it's almost a sort of strict liability in a sense.
Yeah.
So that is something. Other than that, there is, in October 26, various other trade union rights being introduced, rights of access, rights to certain facilities, and so on. And then, as I said, 1st of January 27, we have a reduction in the qualifying period for protection against ordinary unfair dismissal from 2 years to 6 months. That's probably the most headline-grabbing change. And bear in mind that if, as of the 1st of January, I only need 6 months continuous service to claim unfair dismissal, it means anyone employed from the beginning of July 2026 will fall within that 6 months. So what it means in reality is that employers need to be looking now at things like probationary periods, notice periods, etc., performance management policies, because anyone you take on from the beginning of July will gain protection against ordinary unfair dismissal on the 1st of January onwards. So, you know, what it means is you're in the slightly bizarre situation that if on the 1st of July 2026 I was a new starter, and if on the 1st of July 2026 I had 6 months left to run on my 2 years continuous service, I'm in the same boat. You know, we will both get protection on the 1st of January. And I think that there can be a risk that some employers will think that somehow this right only begins on the 1st of January. Well, actually, no, anyone with 6 months as of the 1st of January gets that protection.
Yeah, that's an important distinction, isn't it?
Yeah, no, it is. It is. And then in 2027, we're not sure when, but presumably either April or October, there will be additional protection against dismissal during or after pregnancy. There will be potentially additional protection against dismissal during or after other statutory family leave. So you can imagine that shared parental leave and adoption leave at the very least will have to mirror the protection for maternity. Action plans on gender equality and supporting employees through the menopause will come in. Those are mandatory. Changes to the threshold number of staff for collective consultation. At the moment, if you make 20 or more people at one establishment redundant in a 3-month period, the collective consultation kicks in. What we're going to see is that will remain, but there will be a supplemental that if within a 3-month period you make more than a threshold number of staff across the whole business redundant, it will kickstart the collective consultation obligations. Question to be clarified is, what will that threshold be? I'm assuming it's going to be a percentage of the whole workforce. You can see the logic in that.
Yeah.
But where they set the percentage will indicate how much of an impact that will be. Flexible working, the changes there, the idea that not only if you reject a request for flexible working, you'll have to base it on one or more of the existing 8 business reasons. But in addition, it will have to have been reasonable for you to do so, which means tribunals can scrutinize your thinking. General bereavement leave will come in. And then, of course, I suppose the world's most complicated provision, that's the rights for 0 and low hours workers and low hours agency workers to be given a guaranteed contract of hours after 12 weeks. So they will work out the average for the previous 12 weeks, and employers or hirers have to offer that as a guarantee. You don't have to accept it, but the employer has to offer it. And of course, the real oddity there is that if I have been engaging an agency worker for 12 or more weeks, I not only have to offer them a guaranteed number of hours based upon the average hours I've given them over the last 12 weeks, but they become my worker as well, presumably my employee. So presumably their employment would transfer from the agency to the hirer if they were employed by the agency. So, lots happening. I think the initial things this April are primarily around unions. But, and I think things that are not that contentious, parental and potentially becoming a day one right, for example.
Yeah.
I think, as always with this, what we've also got, which complicates it, I think we had 5 consultation papers published last week. And what we're trying to catch our breath with is, well, how will the actual regulations that flesh out these provisions look once we've had responses to the consultation papers? Because, if you look at things like the trade union changes, there's very little time, before that becomes law. So presumably, when the consultations close for those, what you're going to get is a fairly fast-tracked set of regulations to flesh out, or in some cases, codes of practice to flesh out what these things mean in practice. And I would imagine, and there are 2 things, aren't there? If I already have a unionized workforce, there are going to be enhanced rights of access and facilities, etc. If
Yeah.
I don't have a unionized workforce, and I'm thinking here of the likes perhaps of Amazon, who
Yes.
in the past have fought statutory recognition, well, the chances are that the simplified formal recognition process will be used pretty swiftly by any unions trying to get in there. And so, I think for large non-unionized employers, the potential there is you can see, in April, suddenly facing interest from a number of unions who would like to represent their workforce.
Yeah. Yeah. And the lack of detail to some of this is still quite unhelpful, isn't it? I know certainly from my experience that employers are worried about some of these changes and the lack of detail that we've got as to what they might look like in practice. And I suppose the point be from an employment lawyer perspective is how on earth all of these additional rights are going to be enforced again in practice, because I know we certainly had a couple of weeks ago our first final hearing listing in 2029. So if individuals are already having to wait, I suppose, 3 years to get any kind of justice or decision or, determination on their case. I can only envisage that side of things getting more backlogged and more prolonged. And yeah, it does feel like there's an awful lot here. and,
Yeah, and I think, the law of unintended consequences comes in here. I mean, there are 2 things that strike me. I mean, the first is when you reduce the qualifying period for ordinary unfair dismissal from 6 months, sorry, from 2 years to 6 months, the number of people who will become eligible to bring a claim will go up.
yeah.
But the law of unintended consequences is, I think there'll be a lot more people dismissed in months sort of 3 and 4 of their new employment by employers who don't want to take a chance.
Yeah.
And of course, the irony being that if the number of claims goes up, that long waiting list becomes even longer
Yeah.
unless they significantly resource it. I think also, if you look at something like the very complex new rights for zero and low hours workers and agency workers,
Yeah.
what you're going to face is, let's be honest, a lot of people who are on those sorts of contracts, yes, they might be a student for whom this is really useful, but often, they are low paid. They're unlikely to have legal representation. And so what you've got are complex new rules that can only be enforced in an employment tribunal. And potentially, if I think, for example, my employer should have offered me a 20-hour-a-week guaranteed contract and they're only still offering me 10, and I think that's unfair, am I really going to be hanging around for 3 years
Yeah.
waiting for? And whilst there are avoidance provisions, anti-avoidance provisions in things like these sort of guaranteed hours for zero and low hours workers, you and I know that one of the things that people will ask themselves is, how do I avoid the anti-avoidance provisions? Because it's a bit like the agency workers regs 2010, where you get certain rights at 12 weeks, where we all know that a number of organizations just adopt a blanket policy of never having an agency worker for more than, say, 6 weeks without
Yeah.
having a break. So again, it's this law of unintended consequences.
Yeah.
Are the very people who this is meant to protect going to be the ones that lose out?
It's
Because,
suffer.
well, I heard one employer who is a regular user of low hours staff because it suits them. And they said, well, look, rather than employ 10 people on 5 hours a week or 8 hours a week, I'll just get rid of them all and employ 2 people full time because I'm much safer having a full timer.
Yeah.
I just my exposure. And so suddenly I think we're in a job market where AI has impacted the sort of jobs that leavers and graduates get. A lot of those first-time jobs are being impacted by AI. And I think the trouble with this additional protection, it's terrific if you're an existing employee, but you've got to get a job in the first place. And if what happens as a result of this is that the job market for first-time workers, young workers, becomes even more difficult, then it seems to me that there is a risk that some of this becomes counterproductive.
Yeah, and especially with that point around agency workers, and after after the 12 weeks, they're taken on by the hirer rather than the agency if they're on the low hours contracts and that type of thing. We know that in practice that's going to be really, really complicated and
Yeah,
difficult
yeah,
to deal with. And we know even with the agency worker regulations, people do slip through the cracks,
yeah, yeah.
unintentionally, go over that 12-week period, might not be necessarily offered the same things because they just, it not an intentional you know, differentiation or anything like that. It's literally just, it's not been flagged somewhere on somebody's system that they've hit the 12-week mark. And you just think the potential fallout of something like that combined with the complexity of it.
Yeah.
Yeah, there's it
I mean, and there are two things there, aren't they? What the ERA says is that the contract you offer must be not less favourable than their existing contract, and that's going to be open to debate because presumably there are certain things which, by definition, I wouldn't necessarily apply to someone who's working a larger number of hours or guaranteed hours than I might to someone who's on a very variable contract because it just might not make sense. Um, I think. Yeah, the other thing with this is we're used to the idea that when someone's employment transfers from one employer to another, typically under TUPE,
yeah,
all their rights and obligations pass as if the contract had always been with the receiving employer. And so, of course, if I've got an outstanding equal pay claim or discrimination claim against the agency by
Yeah.
whom I'm employed, does that transfer to the hirer, or does it remain with the agency? Because, this is a very real thing. If I suddenly find that I've inherited someone who has got some horrendous equal pay claim worth a fortune, well, frankly, I think I'd rather just breach the regulations and not take them on. And so when I take on someone from an agency, do I do due diligence and say, I'm only interested in having agency workers who have no outstanding claims against you, no outstanding grievances? Or when I enter into a commercial relationship with an agency, do I include indemnity provisions that say,
Yeah.
in the event that they transfer, I can look to you for any damages or compensation, and you will give evidence in a trial. You can see, aside from the obvious thing, is the agency model seems to me to be potentially blown out the water if after 12 weeks, they're no longer working for me, but for the hirer.
Yeah, and I mean the practical side of that as well is that the hirer will not have a direct contractual relationship with the individual, prior to that
Yeah.
12-week period, and are likely to have no knowledge at all or very little knowledge as to what is actually contained within the contract
Mm.
between the individual and the agency. And there might be situations where as a hirer, you're then stuck with a load of individuals who've been working for you for 12 weeks that suddenly become employees or workers of
Yeah.
your business with contracts that that you've never seen, that you have no idea what
You could
terms
end
and
up with a two
conditions
tier.
there
I mean, it
are.
seems to me if I'm liaising with, I don't know, Manpower, whoever it happens to be, if I'm so if I am a large employer and I'm a regular user of large numbers of agency workers, and we have some clients who do use, thousands of agency workers, it seems to me the starting point is going to have to be we want to see their standard terms and conditions.
Yeah.
And essentially, what we're going to have to work out, because the anti-avoidance provisions, it seems to me that commercial reality is such that is it avoidance for a hirer to go, look, we don't want to take on anybody. The reason why we use agency staff is we're not sure of the numbers needed. It gives us flexibility, etc. So actually, this isn't avoiding these provisions. This is saying our commercial model is such
Yeah.
we can't afford to have all these people as employees. So actually, if I then say, I don't want any agency work, I'll have them for 4 weeks, and then they must go away for 2 months, then they can come back for another 4 weeks, go away. You can see that someone is going to say, well, when the regulations are published and we look at the anti-avoidance, how do we avoid it? Because in order to run a business commercially, we cannot. And of course, it's again that law of unintended consequences that
Yeah.
someone who might have been pretty much guaranteed a reasonable amount of low hours work per week suddenly finds himself being rotated. And it could work, I guess. I mean, if I work for Pret for 4 weeks and then Costa Coffee for 4 weeks and then, I don't know, a supermarket for 4 weeks and then I'm back to Pret for weeks. I mean, it could work. It's pretty clumsy.
Yeah.
And at some point, no doubt someone will challenge it. Well, again, good luck because, 3 years waiting list to get on there. But it just seems to me that in a job market, which is already difficult, where you've got record numbers of people not working between the ages of 18 and 34, who are more likely to be using this sort of work as a first job. And I absolutely get the need to protect zero and low hours workers from unscrupulous
Oh,
employers.
absolutely. I don't think there's any doubt about
No,
that, is there? But it's
they're going about it in a very, very complex way.
Yeah. And as you say, it's the unintended consequence of this, isn't it? So absolutely, I don't think there's any anyone that would argue that, you know, they're not entitled to these additional rights and that it's a good thing to do in principle. But it's absolutely it's that other side of things, isn't it?
Yeah,
As to, well,
yeah.
what will it actually mean in practice, and what will employers do? You know,
And I think, to be honest, that kind of characterizes the Employment Rights Act 2025 as a
yeah,
whole. Lots of things that are good in principle,
yeah,
but the way they are being introduced seems to me to be overly complicated and not striking the right commercial balance.
yeah,
If you take fire and rehire, there is a world of difference between what P&O ferries did and what a local authority does when it's got a couple of awkward squad members who don't want to agree a change that has been agreed following consultation with a union for the whole of the rest
yes,
of the staff.
yeah,
And it's just daft, actually. And it seems to me that one probably could have given the necessary protection by introducing much more punitive terms, So if you think with things like data protection, where you can have up to 4% of worldwide turnover as a fine, you'd very quickly stop P&O ferries and their ilk if you just made it commercially non-viable to do what they
yes,
did. And I think there is a risk that with a lot of these changes, I think ultimately the problem is that you have an act that was born out of general election manifesto promises,
hmm,
and for ideological reasons, it was felt necessary to adhere to certain lines in the sand, even if they don't make a whole load of commercial sense.
yeah, no, absolutely, absolutely. Okay, well, thank you very much, Mark, as always, for those helpful insights. And thank you everybody for listening to us. Do keep an ear out for our other important employment law updates by subscribing to our podcast, the Employment Law Insights. For now, if you do need any assistance with anything employment or HR related, then please feel free to either contact myself at rebecca.kearney@waitmans.com or Mark on mark.landon@waitmans.com. But thank you again, Mark, for providing us with those updates.
Okay, cheers. Bye bye.
Bye. Bye.